Former Senate President Soto said that there are two conflicting rules defining whether or not the impeachment trial of Vice President Sara Duterte can cross over from the 19th Congress to the 19th Congress, which ends its term on June 13, to the 20th Congress, which begins its term on July 21.
Makakatawid ba o hindi? Based on those two rules, both of the impeachment court, the rules of the Senate as an impeachment court, and the rules of the Senate as a legislative body. Kaya nga very controversial issue sapagkat ano yun, judicial work, part of the work of the Senate as mandated by the Constitution.
One thing's clear, nearly a week since the Vice President was impeached by Congress, lots of big questions remain. And to help us with some answers, we have with us tonight Paolo Tamase, Assistant Professor at the UP College of Law in Diliman and Bonifacio Global City. And he wrote an impeachment primer on what we can all expect from the process. Welcome to the Big Story, Professor. Thanks for joining us.
Hi, good evening. Thank you for having me.
I don't know if you heard if you understood the soundbite of Soto just before we came to you, but he said something along the lines of there are two conflicting rules around the question of whether or not the 19th Congress, which is the incumbent, can take up can convene as an impeachment court, and then for it to cross over to the 20th Congress. So the 19th Congress expires on June 3rd. And the 20th Congress only takes over July 21st. What does the Constitution say? What does your impeachment primer say about that?
So our primer, which I co-wrote with four of my former students, and I think the credit really goes to them as well. The primer acknowledges that this is a very gray area in the Constitution. I wish the text were clearer as to whether one Senate can continue over from a previous Senate that started an impeachment trial. But unfortunately, the text isn't just that clear. And so the primer really desists from taking a firm position for now and simply just presents the two theories. And basically, it depends on how you view the Senate. Is the Senate a continuing body that can exist despite the lapse of the term of the present Senate on June 30, or does it end its term on June 30, and therefore you have to transfer or you have to start anew as a Congress?
Since this is one of the more confusing things without precedent, Pao, I was wondering, how do we try to resolve this impasse? It would seem even the most, highest legal luminary, sometimes they also get confused, sometimes they change what they say, their opinion. So right now, everything's an opinion. Do we run to the SC to try to figure out what this exactly means for us to finally have a definitive answer to this question?
The difficulty with going to the Supreme Court at this point is that there might not be an actual case for it. And in the past, which we tried to make clear in the primer as well, the court really tries to avoid deciding difficult questions on impeachment and instead lets the Senate and the House iron it out before stepping in. So a lot of it will depend on the current Senate. The Senate is really in charge of the impeachment trial. The Constitution gives it a lot of prerogative in terms of the procedure it's supposed to undertake, and possibly in terms of understanding how the change in terms will affect its proceeding. But so far, as I understand it, the Senate isn't doing or plans to do anything, at least for now, until June.
So if we go by that, and if largely it will be up to the House leader, or at least the House and the Senate, or both houses of Congress to decide, then pretty much what Senate President Chis Escudero has been saying, that's kind of what we will be following, right? In a sense, he personally believes, he is of the opinion that it can cross over. So are we likely to see that happening?
That is a possibility. I know that we are used in our system to having the court speak with some authority as to how to interpret the Constitution, but there's a reason why it doesn't really interfere in impeachment. And that's because the character of the proceeding is that this is the last check that the political branches have on who gets to serve or continue to serve in government and possibly even hold future office in government. So it gives a lot of leeway to the Senate and the House. And unfortunately, unlike the courts, where you have very detailed, long explanations of why a court decides this way or the other way. The Senate really does a lot of it by precedent, by its own legislative practice, and really by politics. And that's really just part of the system and the haziness of impeachment, which makes it very interesting, but also quite difficult as a process.
Well, Prof, I also wanted to ask about the timeline because under the Constitution, particularly paragraph 4, Article 11, Section 3, it uses the words shall, and forthwith to describe the trial by the Senate. Help us understand the use of the words shall and forthwith. Does that mean as soon as possible? I mean, we're not lawyers here, but I mean, what does that mean?
Everyone's been saying forthwith.
I'm sure Merriam-Webster Online has been getting a lot of hits on the word forthwith, which actually technically means immediately,
Yes.
without delay. But again, it's been open to legal interpretation.
Yeah, I do want to emphasize that when it gets to the Constitution, the interpretation of non-lawyers is more important than the interpretation of lawyers. It's the people's document. In theory, every person who voted for it in 1987 said yes to it and had a role in drafting it. And so the common understanding of forthwith does matter. When that said, if whenever the Constitution uses the word forthwith, it has always meant without delay. So, or as a matter of course. And therefore, the typical understanding is that the Senate should start trial soon. I know that the reasoning that the Senate has provided is that it's on recess and a pre-declared recess at that until June. But the prevailing view or the emerging view, at least among scholars and academics and former justices, is that the function of the Senate when it comes to impeachment isn't really legislative. And so they're not so much as bound to the typical sessions that they have declared. The Senate can simply call itself into order and conduct the impeachment trial, as the Constitution seems to suggest in its text.
Yeah, but if the senators say, well, you know, as soon as possible is as soon as we reconvene, which is in June, then we'll take it up then, that also kind of holds, right? I mean, you can't also say, oh, no, that's a wrong way of looking at it or interpreting it.
Yes, so the Senate can also say that as soon as possible actually means that when it resumes sessions. And again, we go back to the discomfort around the haziness of impeachment, the uncertainty behind impeachment, and it's really just inherent in it as a political process. So it emphasizes something else in the Constitution, which we often don't emphasize in discussions, and that's the democratic character of this process, impeachment. So it's supposed to be done not by lawyers or by judges. It's supposed to be decided by people who actually are voted on because of politics. And so it's just inherent in that type of the process that unfortunately a lot of these questions, very interesting questions that have been coming up, are just not answerable without the Senate actually essentially taking the first step, or somebody filing a case in the Supreme Court and hoping that the court would actually take action contrary to what it has done in the past.
I have another question that's very confusing that came out. So I heard one of the panel prosecutors, Attorney Luistra, saying she is of the opinion, of course, she's also a lawyer. She said that if the vice president resigns before the Senate convicts, that the trial can continue. And there seems to be also dissenting opinions on that one. What would be yours?
My own view, and the primer does present both views, but my own academic view is it can continue despite the resignation. And the reason why that's the case is if you look at the text of the Article 11 itself, it does say that the penalty for impeachment shall not extend beyond removal from office and disqualification from holding further office. That second clause is often overlooked. And therefore, if we look at the process by how impeachments have gone in the past, the Senate has actually desisted from taking further action after a resignation. So this has been cited in various news reports. Ombudsman Mercedes Gutierrez, Chairman Andy Bautista, when they resigned, their impeachment trials did not proceed. And in the case of former President Estrada, when he resigned, the impeachment trial actually pre-terminated without a ruling. But other than the text itself, which suggests that the Senate should have some say on whether the official is not only removed but can still hold office after, you also have to account that this is really an accountability mechanism. And therefore, it might be frustrating that mechanism in the Constitution if an official can just resign if it doesn't look like he or she is going to win his or her impeachment trial. So the Senate should have that word eventually, I think.
In short, the Constitution is silent on whether or not the Vice President could be permanently banned from public office if she resigns before conviction.
Yes, so it's not so much that it's silent; it's ambiguous. The text itself could be read in either way, and there are some people. I think Justice Carpio has come up with an opinion that resignation would result in the termination of the trial, or the trial not even happening if she resigns before. But there is an emerging view, and I think a lot of it is driven by developments in the United States. So if you look at 4 years ago during the second Trump impeachment trial, the trial actually commenced after he left office. And the Senate had to deal with a procedural motion to stop the trial of President Trump because he had already left office. The Senate voted along bipartisan lines, 55 to 45. The US Senate decided to continue with the trial and acquitted him nevertheless. But proceeding to trial kind of indicates it sees its power as not frustrated by the termination of office of the impeachable officer.
That's the
And,
other.
and just to add, right, the US Senate practice is quite important because we do take this particular contentious provision from the US Constitution. We follow very closely the wording of their equivalent provision. And so, as with many provisions that we take from the American Constitution, what their bodies do kind of informs us as to how that word or those words originally meant.
Okay, I did hear another constitutionalist actually in another interview say this exact thing. In the absence of precedent, look at the U.S. Constitution. And I wasn't quite sure, to be honest with you, how I felt about that. So you're saying that's actually something that is, in fact, done.
Yes, it's very accepted practice, and I understand the discomfort. My own scholarship, the scholarship of my colleagues in the University of the Philippines, is a little uncomfortable with how much we actually take from the Americans in interpreting the Constitution. But it's one of those things that gives a little bit of stability to how we understand it. Basically, the thought is that if it was written into our Constitution in 1987 and the text was purposely copied from the American Constitution, then there may have been some intent on the part of the people who drafted the Philippine Constitution to take from American practice. So recent jurisprudence has really tried to pull back from that over reliance. But when it comes to these very difficult provisions, very technical provisions, it seems like the American practice would still be somewhat of a good guide in terms of understanding these vague provisions of our Constitution.
The Senate holds all the power now,
Yeah.
in short.
Yeah, I mean, we're basically waiting for the Senate to make a definitive move. And I know that the Senate President, Chisa Escudero, has made statements in public and in the media in the last few days. But there are 22 other senators who are, haven't been heard yet. I think they're unified in terms of being a caucus, but it would be interesting to also get the views of the other senators as to whether they feel that trial should proceed or not.